if I could call on you to highlight the key differences between three concepts: a retainer, a cost agreement, and cost disclosure, and explain why understanding these differences is so important.
Thanks, Mike. I must say, in my experience, Mike's correct that many lawyers, and in fact some cost lawyers actually, don't draw the distinction, in particular between retainers and cost agreements, and then also between cost agreements and disclosures. A retainer is simply the contract between yourself and your client to undertake legal work. Now, a retainer can and is often an oral contract. So as soon as a client rings you up and says, I want you to do A, B, C, they are retaining you.
And just talk about the whole issue of using ranges and what is allowed in the terms and conditions.
I think this is on. Well, what we would say about ranges is the idea of giving disclosures to allow the client to make an informed decision about whether or not to proceed. And therefore, one of the requirements is to give an estimate of the total legal costs. Now, it's an estimate, it's not a quote, but that doesn't mean, in our view, that the estimate can be so uncertain as to be meaningless. So I suppose the short answer is ranges in an estimate are fine, so long as they're not so broad as to be meaningless. And we've seen a lot of estimates given over the previous legislation under the Legal Profession Act, and sometimes it'll range from $500 to $50,000. Now, that may, in the broader sense, be true, depending on how the matter unfolds, but it's not useful and it's not a reliable estimate that the client can base their decision on. So we would say small ranges generally are okay. As I said, if it's between $850 and $900, then that does give some certainty, but if it's between $50 and $50,000, it's not so certain.
So principal, is anybody here in the room a principal of a law firm? Is anybody here a director of a law firm? Couple. Has anybody read the definition of principal under uniform law? Yes, good. Excellent. Now the reason why I ask is that under the Legal Profession Act, people started being called principals who actually weren't either partners or validly appointed directors. So there's a kind of term in a firm that you were a principal. We've all heard that, instead of promoting somebody to a partner, you might call them a principal. Now there's a definition in the uniform law of a principal, and it's a very important definition. I urge you all to read the definition in section 16 definitions. I'll read it out. A principal law practice is an Australian legal practitioner. Sole practitioner, it's the sole principal or sole practitioner. In a law firm, a general partnership is a partner, so it's a validly appointed partner. In a partnership of ILPs, it's a principal of the partner ILP. And an ILP itself, it's a person who holds a principal's practice as a validly appointed director. Now, and aside of that, for those who are directors of law firms, make sure that you're actually validly appointed. Does anybody do you have a record of being appointed a director? Well, firstly, the corporation actually should do, and secondly, you wouldn't want to have to run that defence or the commissioner say to you, well, actually, are you validly appointed? Because you're then holding yourself out. There's a few issues there, but make sure you're actually validly appointed. Have a register of who's appointed and when you were appointed and what's the authorisation. That probably should apply to all principals, but especially for directors.
With the compliance audit, and the one that I did, and it should be noted too that we always, nearly 90% of cases, we also go out with someone from the Law Institute as a co-auditor. So we go out together. Even things that come up are even simple things like, have you got access to a mentor? Do you have a mentor to assist you? Can you go and talk to someone? Do you have a barrister that you talk to? We look for things like, are your documents kept safely? Do you give letters of advice? We usually look through probably 10 or 12 files to see how matters are run. That there is regular communication with clients.